What's up, everyone? Welcome into Case by Case with Peter Tragos. And we have a ton of potential cases to talk about tonight. I know we've got some listed in the title. We'll get to some of those. But a lot of stuff has been going on this week. So we have a lot of new things that we're going to discuss, things that have kind of just started happening, like the Alec Baldwin lawsuit. We have a Prince Andrew settlement. We have a Brian Flores update. We're going to talk Brian Laundrie. We're going to talk Curtis Reeves. We're going to talk about a ton of cases. We'll take them one at a time. We'll go through them. Make sure, as always, you get into the comments. Let me know your questions. Let me know what you're thinking about these cases. And let me know what content and cases you want to talk about in today's live, because you guys really drive the discussion of what we discuss. So to start out, I'm going to start with Brian Laundrie because I think there are some interesting things with this medical examiner's report that's come out. It was like 50 pages. A lot of people made a big deal about how long it was. A lot of it was just kind of listing body parts that they found. And there wasn't a ton of information in there, but there are a few things about that case that give me a little sneaking suspicion that something is going on and they're not sharing something with us for some reason. So we finally, for sure determined that Brian Laundrie died from a self-inflicted gunshot wound to the head. We have confirmation that he admits killing Gabby Petito in one of his journals or notebooks. We have references to multiple journals and notebooks and notes on a half of a piece of paper and weird things like that. There were some gruesome, gory details about how his body was basically just bones because it had been scavenged by animals and the elements, basically, which broke it down to nothing but bones. So, that's not great, but that's kind of the condition that they found him in. The most interesting thing to me about the entire Brian Laundrie situation right now and in connection with Gabby Petito is, why are they not turning over, disclosing, explaining in more detail what is in the notebooks and the journals? We know that there's an admission that he's responsible for Gabby's death. We haven't really gotten any more detail than that. And I'm starting to wonder if there's some, like, he inculpates or like he makes some kind of culpability discussion for law enforcement. Does he say, I talked to the cops, they didn't even ask me anything about it, I saw them, they're right there, how do they not see me, they keep walking right by me? Something like that, that shows that maybe law enforcement could have done something more than they did. I'm not saying that, but I think that potentially that could be something, there could be something negative in the notebook about the people that found the notebook and the people that have control over the notebook that I would expect to come out eventually in some sort of investigation, even if it's a civil investigation, because I think Gabby Petito's parents have a right to know what's in those notebooks. And if there are certain lawsuits filed, they could potentially get their hands on them. But to me, it's very strange that we're not getting any more detail about what is in the notebooks, the journals, whatever you want to call them. There were multiple books where he kept his thoughts or wrote down certain things that could be important and could be material. The next thing on the list that I find interesting is Prince Andrew has settled with Miss Giuffre in the sexual abuse lawsuit that she filed, that he's denying up and down. And it just so happens that the timing of this settlement comes right before he is supposed to be deposed under oath. And before his deposition is taken, before pen hits paper, or actually typewriter starts typing and puts it in black and white, he settles. And as we've seen in the Ghislaine Maxwell case and lots of other cases, once your deposition is taken, it can be picked apart. It can be used to impeach you if you ever make any other inconsistent statements. And you can accidentally say things you may not want to say or you may not mean. And so he wanted to avoid that deposition at all costs, at least is what it sounds like with the timing of the settlement, and he settles the case. Now, a couple of important things in the settlement. And if you remember the Deshaun Watson case, which is still going on, both lawyers and both sides are pounding their chest about there will be no confidentiality. Everybody's going to know the outcome of this case. We want the world to know the facts and the truth and what really happened. Well, in this case, the amount of the settlement is confidential, and there's no admission of wrongdoing on the part of Prince Andrew. So he can still claim, listen, wasn't worth my time. I didn't want to get dragged through the mud. I was afraid of criminal stuff coming. So I just settled the case even though I did nothing wrong. And this is the problem with these, leeches trying to take money from everybody. So we might never know any more detail about this because now I assume Virginia is under a confidentiality agreement, under a non-disparagement clause, potentially, that she is not allowed to disparage him anymore in the future in public. Most of the time, those things are included in a settlement agreement. But we know that this is going to be cloaked in secrecy. We are not going to find out a lot of details. Now, if you want to make an educated guess as to what she got, if you listen to, in the Maxwell case, a lot of the victims, their settlements were in the 7-figure amount. But they didn't even call Virginia in the trial, which probably indicates she's not as strong of a witness or didn't have as strong of evidence that was as damning as some of these victims that had million or multi-million dollar settlements. So I think we can assume it's a little bit less than theirs. Additionally, Prince Andrew's got plenty of money, but it's not exactly the Epstein fund. So maybe not a 7-figure settlement. I would guess it's in the high 6 figures. That would be kind of my educated guess. Over 500,000, less than $1 million. That's kind of my guess. And I could be wrong. I don't really have any way of knowing what the settlement amount is. I'm just looking at the details from some similar cases and some things surrounding these facts. So again, just my educated guess. Next, a little Brian Flores update. He, at least it's been reported, that he is going to amend his complaint and he is going to add the Houston Texans, who just hired Lovie Smith, who is a black coach and was their defensive coordinator. They hired Lovie Smith after narrowing it down to 2 or 3 candidates, and Brian Flores was one of those candidates. I haven't heard if they're going to do it with the Saints too. I don't know why they wouldn't. I don't know what the difference is between the Texans and the Saints, except the Saints hired a white guy, Dennis Allen, also their defensive coordinator, who they promoted to head coach. So similar circumstances. But, and I'll tell you a difference, which is funny, and I commented on Twitter about it. But so they're going to add the Texans and amend the complaint to add a claim for retaliation. And the retaliation is for Brian Flores not being hired as a result of him filing the discrimination lawsuit against the NFL. And at least in federal court, which is all the retaliation claims that I've ever handled, it has to be an intentional act, and it's basically a form of discrimination. And you're discriminating against an employee or a potential employee or making a hiring decision in retaliation for a protected action. That's what's important. It has to be a protected action. And a protected action is, and what's included in that is filing a complaint on behalf of a protected class or calling out wrongdoing. You cannot label those people as troublemakers who are not going to be hired or who are going to be fired for making waves as whistleblower type of things. So he is going to fold this retaliation claim into the lawsuit, saying that now the Texans and potentially other teams are retaliating against him and not hiring him as a head coach because he has shined a light on what's actually happening in the NFL, which in his opinion is racist hiring practices. Very interesting to me, and a very interesting update. All right. Real quick second on Alec Baldwin. I did a video on that today on what the lawyers for Helena Hutchins and her family explained about their complaint. And a lot more people than I was expecting wanted me to do a deep dive into the complaint. So for those of you who are here, if you want this video to be that deep dive, I can pull up the complaint here and I can go through the complaint in detail. But what I want you to do in the chat is, again, to comment complaint. And if I'll say, I don't know, 25 of you comment complaint in the chat, then after we answer some questions, I will do a deep dive into that complaint that Helena Hutchins and her family filed, the estate of Helena Hutchins, filed against Alec Baldwin and a set of defendants. And we can talk through it in more detail. Figured most of you would want it because we talked about a lot of these facts, but there are some interesting things in the complaint. So if you want to talk about it, we can do that kind of later on in this video. And then Curtis Reeves did a breakdown of a cross-examination of one of the witnesses. We've talked through that case a lot. So for Reeves, what I'm going to do is let you put some questions in the chat and I'll answer those questions. I was only able to catch some bits and pieces of it today, but I have caught a lot of the trial, a lot of the witnesses, a lot of the arguments in both openings. So we can answer some questions on Curtis Reeves. But what I want to do now, before we get to the questions, again, get in the chat, give me the questions that you guys have, and I'm going to go through them. Whatever case you want to talk about. This is case by case. We can talk about any of the cases. But what I want to do first is share this screen if I can figure out how, because we're going to do a little let's see here. We're going to do a little discussion about the merch. It has happened. We have merch up. It's lawyeryouknow.creatorspring.com. I don't know if that's how you get to it, but that's the website that's showing on my page. So we have merch on here. We've got some of our sayings. The evidence will show. We've got case by case. We've got the lawyer you know. We've got some future lawyer merch for you or the kids out there. We've got hoodies. We've got sweatshirts. We've got t-shirts. We've got shirts for the ladies or guys, if you're into that. We got cups. We got mugs. We got bags. And then a couple of my favorite sayings on here is, let's see, this one is cool. It says, my opinion matters, potential juror, which is a lot of what we talk about on the show, that I want to hear from you guys because you are potential jurors and it is really important and your opinion is really important. Another one that I really liked, legal questions, question mark. And then in small print, I'm not a lawyer, but I subscribe to the lawyer you know. So that's pretty cool as well, in my opinion. I thought that was all cool. And then we had a bunch of designs submitted. And the one that we picked from subscribers specifically was this one here, case by case at Tragos Law. And, you know, she tugged at my heartstrings a little bit with the garnet and gold Florida State colors. You got to know your audience here if you're trying to win something. And the winner is Dawn DeQuisto, who is a subscriber. She's in a lot of the chats. She comments a lot. So I know that she is here a lot. I know she will either see this during the live or afterwards. Email us, lawyeryouknow@gmail.com. Your t-shirt size, sweatshirt size, whatever you want, and your address if you want us to send you some of the merch that you designed. So if you guys have any designs, we're going to continuously update it. I can't control when it's out of stock. I don't even really know how all this stuff works, but feel free to go out there and buy it if you want it. Don't feel like you have to. Don't feel pressured to at all. We had a lot of people ask, I'm going to buy a bunch of stuff. I'm going to buy some stuff for my kids, the future lawyer stuff. My wife wants some of the shirts and sweatshirts and stuff, so it's going to be fun. It would be amazing if I saw somebody walking around with it. It would be hilarious. But yeah, go ahead and buy the merch if you want to. This is really cool. It's fun, something that we can do together. So do it if you want to. So that's the merch. That's the update. That's the winner. And other people can still win if we pick some other designs. If you have a design, you can still send it to us. Absolutely. And we will dig into it. And we will pick a winner if there are some that we end up putting on the site. Okay. So I think that's all that I have kind of for the opening part of the video. So I'm going to go to the chat here. I'm going to answer some questions, hopefully specifically about Reeves, because that's one of the topics that's hot right now and that a lot of people have questions on. And then we're going to see if we get to 25 comments asking for a deeper dive into the complaint, which we can do kind of near the end of the video. All right. If Mr. Reeves believed he was in danger of his life, even if he wasn't, is that still considered self-defense? Great question. And this is the ultimate question for the jury. It is Mr. Reeves himself, a 71-year-old man, former cop, 6'2", 270 pounds in this situation. So it is subjectively him. Okay. His subjective belief, but it has to be a reasonable belief. So it has to be a reasonable person standard. Is it reasonable for a 71-year-old former captain law enforcement officer who's 6'2", 270 pounds? Is it reasonable for someone like him and someone in his situation to believe they were in fear for their life or serious bodily harm in order to respond with deadly force in order to make it a justified shooting or self-defense? So he can't unreasonably believe it. I can't just be super scared of everything all the time, and because somebody coughed, I think that they're going to kill me and I shoot them. That's not reasonable. Even if I, in my head, believe that subjectively, that's not reasonable. It's not always that easy, but I think that's why the prosecutors and the media and a lot of people are calling it the popcorn shooting, because they're trying to really show how unreasonable it is. Now, I think the defense has shown that it's a little bit more than a popcorn shooting. We could have a cell phone thrown. We could have potential threatening body language coming over the seat, pointing his face, cussing at him. A tall guy, 6'4", angry, raising hell. Now, I personally don't believe it raises to the reasonable person standard that he had a reasonable fear. But I think it is more than just a popcorn shooting, that some popcorn was flicked in the air and he turned around and shot and killed the guy. So I still think it's more. Hopefully that answered your question. Kim Brody asked, could it be fake? And he took off. This is talking about Brian Laundrie. It's really hard to fake dental records. They had jaw and teeth, and that's how they identified him. The rest of the body all matched up with white male of his size, his age. So I think it'd be really hard to fake at this point. Bodie, this is about Reeves. Cops know to say the "I feared for my life" rhetoric. I think it is going to cut against him that he is a cop and he knows kind of what the self-defense rules are. And you know, I think on cross, because I do think he's going to take the stand, I think on cross, the state's going to dig into that. Marlene Barone, I still think his father should have followed him when he left or notify the police when he left, and his son could still be alive, knowing his son was grieving, as the lawyer stated, potentially. And again, I think we may learn more about this. I think we may still see more investigation into this case, either civilly or criminally, and see who really could have done something to prevent this, who had information that they should have given to law enforcement. Could law enforcement have done anything? I think there are a lot of layers to this still. Matthew Raftree, if found guilty, Reeves had already served 7 years of his sentence on house arrest. Is this part of the reason for defense not pushing the case to be heard sooner? I believe so. I believe so. His health, the fact that he's on house arrest, not in prison, he gets to be with his family. I think that's a big reason why they haven't really, demanded speedy trial or anything even close to that. Helen Pidgeot. Andrew is not wealthy, so it could be the queen who ends up bailing him out. No idea how he's paying for it. I'm not sure if we'll ever hear it. Matthew, I've heard house arrest doesn't count for time served. Hope that's true. Sometimes it actually does. It depends on the case. All right. All right. We got a bunch of complaints coming through. Vicky, Kyra, Music Buff, Denise. What's up, Denise? Let's see. Michelle, Helen, Linda. I haven't been counting. I should probably be counting. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 so far. All right, Diana McGinnis, Prince Andrew settlement. I understand that he has 30 days in which to pay the money, something about a dismissal. Otherwise, the lawsuit continues. Is that what you have read? Is that a thing? I actually just found out about this right before we started. I have not read the settlement agreement. I think it's confidential. You can put payment deadlines in a settlement agreement. You can say paid in 10 days. You can say 30 days, 60 days, whatever you want. Usually, the dismissal is not filed until the payment is made, so you can kind of hold that. But usually if it's a large sum of money and they pay some of it or they're working with you to pay it, you're not going to continue the lawsuit. You're going to try to get the money. That's the point of the settlement. So, I haven't seen that, but that could very well be a condition of settlement that you have to pay it in 30 days to make it actually over and not drag it out. Hot pick. What are the procedural differences in a civil trial compared to a criminal trial? For example, are objections different? So the main difference is the constitutional rights of the criminal defendant. Criminal defense attorneys have way more leeway than either lawyer or party in a civil case. They have different rights. They obviously have the right to remain silent. In a civil case, each party can force the other party basically to take the stand. Obviously, if you're dealing with law enforcement more in criminal cases, that's a little bit different. The rules of evidence are pretty similar. What's admissible and not admissible is pretty similar. Stylistically and procedurally, one of the big things is every criminal case I've tried, every piece of evidence, you've got to lay the foundation. You've got to fight. There are objections. You have to bring records custodians in. You have to prove it's relevant. And then you have to ask the judge to admit it. The state usually objects, and you kind of got to fight through every piece of evidence that you get in. In a civil case, most of the time, actually, I think every civil case I've had, at least 95% of the evidence we bring in a binder and we say, Judge, here are our joint exhibits. We're entering them into evidence before the trial, and everything's in evidence. And it makes a big difference as to how you try the case, because now I can use all that in opening statement. I can use it with every single witness. I know for a fact what's coming into trial and what's not. We talked about this a little bit in the Arbery case, where they didn't know what jury instruction was going to happen. They obviously didn't agree about it beforehand, and they kind of sunk their ship with their opening statement when they misstated the law on the citizen's arrest explanation. So you've got to know that. And in criminal cases like that, sometimes a lot of things are not agreed to. So you don't know exactly what's going to come into evidence, what's not, what arguments you're going to have to make, what witnesses may be called. So criminal is a little bit more, I don't want to say trial by ambush, but a little bit more unknown can happen. And civil trials, usually you know what's happening up front, but we have different fights in the civil cases. We fight a lot about experts and bills and how much stuff costs and scheduling. And in a criminal case, we work with the prosecutor pretty easily to set everything up. They have most of the witnesses most of the time. So there are some stylistic differences, but procedural, I wouldn't say there's a ton once the trial starts. And again, there are different things you can do in jury instructions based on it being a criminal case or civil case, depending on what the crime is, depending on what the civil action is, on what you can ask them. But again, that's really case by case specific, not even just all civil or all criminal. But to me, one of the biggest things and one of the shocks to me when I first started trying civil cases was, wait, this stuff is just all coming into evidence. We're not going to fight about this, each piece of paper one by one. We don't have to call wet records custodians. So that was interesting to me. Yeah, Diana, I'm sure there's going to be some payment deadline on there. Marlene Brown thinks Northport police dropped the ball. I mean, I think there's more indications of that as the case goes on. Vicky McNamara. Regarding the Hutchins case, how does it work when an investigation is underway? All details are worked out. Can the family amend their case as more investigation is made available? Yes, you can amend your case, usually once for free. After that, you got to ask the judge or get the other side to agree. But so it's really interesting. And this is kind of an internal discussion, a philosophical discussion we have in the firm and on the Civil Rules Committee for the Florida Bar and how we want this stuff to work. You can't just file a complaint and have discovery be this wild goose chase where you just order everything, find problems, and figure out what you're going to sue somebody for. We don't want that. So you have to have a cognizable cause of action. It has to be pled enough to where it tells the defendant what you're suing them for. You have to have a good faith basis. So there has to be enough evidence that you already have before filing a complaint that gives you a good faith basis that the defendant is liable. And then you can find more from there, because there are certain things you just don't have access to, especially when you're suing big companies. You don't have access to a lot of things, and you find that out during discovery. So that's kind of how it works. You don't know everything, but you got to know enough. And you got to appropriately state a claim to which the defense can respond to. You can't just say, I'm suing you, it was your fault. You have to say what they did. Great, I've got the hiccups. All right, and another complaint. I think that's 14. Congrats to Dawn. Great design, Dawn. Hey, new Chris is still open, man. Send in your designs. Anything you want. Any quote that you hear a lot. Any video you like the most. Like we had The Evidence Will Show. We had I'm Not a Lawyer, but I Subscribe to the Lawyer You Know. Case by Case. Tragos Law. Lawyer You Know. Whatever you want. Put it on a shirt. Or actually, I think Dawn even did it like in a spreadsheet. A PowerPoint. Send it over to us. If we like it enough that we put it on a shirt, you will get a shirt sent to you. So please do it. The more, the merrier. Yeah, Michelle Mosby. Looks like Baldwin shot himself in the foot with his explanation. I don't understand why he thought that was a good idea. Would he be in a better position now? Absolutely, he would be in a better position if he kept his mouth shut. They are literally quoting him in press conferences and in complaints with using his own words. And the experts now that all these people are hiring can pick every single thing he said apart. That's what I expect. That's what I've expected from the jump. And that's, what's going to happen in that case. Yes, congrats to Dawn. So Jennifer Son, I actually heard that there was an additional sum of money. And again, I haven't seen this like for sure. So, sometimes it's hard to report on some things that you hear through the grapevine, but I heard there was an additional sum of money that he is going to donate to certain charities of her choice. I don't know if it's going to be the full amount, but to me, it sounded like there was a settlement he was paying her and he was going to give money to the charities. Clistrine's power just went out. Hopefully it was all his hiccuping. I was leaning guilty on Reeves, but his recorded statement has me wondering. Interesting. Miss B, why doesn't the prosecution in the Reeves case point out that the Reeves' cop son was also in the theater? Why would he reasonably believe he would seriously get hurt if his own son was there too? His son was not there until after the shooting. All right. Yeah, Diana's saying the same thing, that there was a settlement to her and then also money to the charity. Bodie, thanks for being here again. I don't know if I've already mentioned this, but Point Break, like one of my all-time favorite movies, like all time. Johnny Utah, Keanu Reeves' character, got a football scholarship to law school, which is like impossible, and then goes to the FBI and is an adrenaline junkie and obviously catches Bodie and the crew. And Bodie is Patrick Swayze, also an amazing, two of the most like amazing characters of all time, favorite movie characters together. And I love it. I love it. Jennifer Son, I think that's 15 complaint votes. So yeah, JVM, I didn't get to watch it again. I know it's on the list and I really want to. I haven't had time to actually sit and watch the preliminary hearing. Preliminary hearings can do a ton in the case. Statements are under oath and can be used at the trial or at future hearings. They're really important. It's really important to the judge. Now the judge is going to make decisions on the case. And it can affect a lot of different things in the case throughout the entire case. Did something crazy happen? Why is everybody talking about the preliminary hearings? I haven't had a chance to watch them yet. I saw that people are saying the parents are like doing signs at each other or whatever so they can communicate, which is interesting, but I don't know. If Reeves is not going to testify, then how can his recorded statement to the cops that night be used? He can't be cross-examined. If the prosecutor is going to use it, they don't need to cross-examine him. His recordings can be used because it's a statement by a party opponent, meaning the opposition, the opposing party's statements can be used in your case in chief. And the right to cross-examine him would be if the defense called him, then the state would have the right to cross-examine him because he has the right to take the stand if he wants to. All right, I think that's 16 complaint. Knew Chris very respectfully. As people get older, they lose their bearings. He's 78. He was 71 at the time. Is he even in his right mind? Was this brought up by the defense? Was he given a breathalyzer after the shooting? I don't think they made any kind of like insanity defense. And I don't think he was breathalyzed. I don't think there was any really indication of alcohol, but I don't think so. Matthew Raftree, yeah. Sometimes they don't take the stand when their recording statement is made. I have always thought he was going to take the stand. If he doesn't, I actually think back to New Chris's comment, maybe they're nervous because he's 78 and he's not as with it as he used to be. But I expect him to take the stand. A guy like that, I expect him to be able to deal with cross and answer those questions. I think his best chance, like I always say, in a self-defense case like this, unless it's obvious self-defense, like the victim pulled a gun on him, I think the defendant has to take the stand and explain it. I think that's your best chance when you're up against it like this. Now, not in every case, but in this case. Yeah, Barry Curran, he was stripped of his titles. She has no liability. Fine. She didn't lose the ability to still pay for it on his behalf, I'll just say. She could still want it to go away because it's still not good for her, the queen, and the royal family that he's being dragged through this. So it wouldn't surprise me if she was kicking in to make this go away. I'm not saying it's happening. I have no idea, but Bodie, do you prefer 6 or 12-person juries and why? Depends on the case. If I've got a good case that I really like, 6. It's hard enough to get 6 people to agree, let alone 12. If it's a tough case, 12. And that's the point, is the capital crimes in Florida, when we get 12 jurors, it's supposed to be hard. It's supposed to be beyond a reasonable doubt, the highest standard. If you're going to potentially take a person's life, you want to be sure. I can't remember who said it. You guys are going to probably just crush me. This was like maybe Thomas Jefferson. Better that 1,000 guilty men go free than one innocent person get convicted and especially killed under the death penalty. Yes, John Grisham, we've discussed Curtis Reeves a bunch, and we've got a bunch of videos on the channel. Feel free to ask any specific questions, and I'll answer them. I think this is 16 for complaint. Yeah, I've heard a lot about. I didn't see all the cops. I saw some of it. Yeah, about how they were seeming biased towards the defendant. So I don't think that does great. Yes, Point Break does totally rock. Wow, we got a lot of Point Break fans in here. That's good. These are my people. Exactly. This is why we all like the same stuff. Okay, his son was at the theater, I guess, but not inside. Still wouldn't affect his reasonable belief of fear or anything like that. All right, I think that's 17 maybe? 17 complaints. Husel trial, Jose Baez starts next week. I honestly have not seen anything about this one. All right, 18 for complaint. Do you believe Curtis Reeves is the initial aggressor here from New Chris? I don't know. I mean, making a demand and going and tattling on somebody, does that make you an aggressor? I think potentially the victim is the initial aggressor here, but not to the level of needing deadly force in a response, I don't think. I mean, standing up, raising hell, pointing at him, leaning over the seat, cursing. But I don't think anything he even said was that threatening. You know, I mean, grabbing the popcorn and throwing it obviously wasn't great. So I don't know if I would call Curtis Reeves the initial aggressor, but I don't think that that's the end-all be-all. Sabrina, I may be pulling back the curtain or busting the bubble. A lot of people carry inside movie theaters. A lot of people, especially in Florida with concealed carry permits, carry everywhere. They carry in church, they carry at schools, they carry all sorts of places they're not supposed to carry, unless there's a metal detector on your way in, like court. They carry all over all the time. Sylvia, thank you. Everybody hit the like button if you haven't already. Yeah, Bodie again. I'm sure he always carried it. Legally Blonde also rocks. That's also a good one too. All right. It was a Ben Franklin quote. I stand corrected. I obviously didn't know who it was. All right. So we're at the bottom here of the questions that everybody had. Let's take a look at this complaint real quick. We didn't get 25, but we will. Let me see here. We'll take a look at it maybe in a less than totally in-depth view. Let me see. Chrome tab. Wrongful death lawsuit. All right. Look like the full page. Yes. Okay, let's do it. Miss B just asked, do you think the wife in the Reeves case could sue for wrongful death? For sure, she could. For sure. All right. So we know it's for wrongful death. Jurisdiction and venue, we don't need to go through. All the parties is kind of interesting. All these different companies that he sued, most of them have to do with production or controlling it. But what I found more interesting is something that we do in cases under the factual allegation here on page 10. The basic rules for safe gun handling include. Now, you don't have to do this in a complaint. This is not something that is necessary. But if you know the public's going to be reading it and people are going to be talking about it, you can put in here a lot of explanation about how bad this really is and how easy it could have been for them to do the right thing. Always treat the gun as if it were loaded. Never point the gun at anything the operator of the gun, in this case, defendant Baldwin, doesn't intend to destroy. Actually, let me scroll up because there was one other interesting thing. Where is it? Okay, here it is. Complaint for wrongful death. On October 1st, defendant Alec Baldwin. Some people were saying, I don't know if he's the lead defendant. Oh, he is. Defendant Alec Baldwin recklessly shot and killed Helena Hutchins on the set of the movie Rust. Defendant Baldwin and the other defendants, none of whom are mentioned by name specifically, in this case failed to perform industry standard safety checks and follow basic gun safety rules while using real guns to produce the movie Rust with fatal consequences. Helena Hutchins deserved to live, and the defendants had the power to prevent her death if they had only held sacrosanct, which I think means like important, their duty to protect the safety of every individual on a set where firearms were present, instead of cutting corners on safety procedures where human lives were at stake, rushing to stay on schedule and ignoring numerous complaints of safety violations. That is kind of the summary, the overall summary. All right, so let me get back to all the gun safety laws rules that they violated. Always keep the gun unloaded. Never place your finger on the trigger. Be sure of the person's target. Learn the mechanical and handling characteristics. Load the gun in front of the actors. Personally perform and observe a visual inspection. All of these rules were there, and they had a gun safety expert, but they didn't use them. The Rust production involved extensive use of firearms and required an experienced firearms expert with the skill and qualifications to maintain constant vigilance for safety matters. And then, to none of our surprise that watch this channel and have discussed this case, defendant Gutierrez Reed was inexperienced in weapons mastery, with only one movie production under her belt, unqualified for the degree of skill required on the Rust set. We knew this was coming. The most basic firearm safety rule in the movie industry is that there must never be live ammunition. Again, something that we all at least should know, and everybody on a movie set should know. What's interesting about this case is they're just going to take basics and make it simple, like throwing popcorn. You've got to know, don't point a loaded gun at somebody, even if you think it's blanks. Look at the gun yourself. Only load it in front of people. And if you have an armorer on the set, they need to be on the set anytime the gun is going to be there, loaded or not. And she wasn't. Defendant Baldwin was on set. Defendant Baldwin was the film's executive producer, lead actor, and contributing writer. Again, they're putting a lot of this on Baldwin. The time of the shooting, Baldwin, Miss Hutchins, and other crew members were doing a lineup of a shootout scene in an old abandoned church. The sole purpose of a lineup was to confirm positioning, frame and focus of the camera for close-up shot of the defendant Baldwin's hand and the revolver he was holding. But Baldwin's possession of a real revolver, let alone a revolver loaded with any ammunition at all, was unnecessary. He didn't even need the revolver. I think we're going to hear that Helena Hutchins told him to bring the gun. I think we're going to hear that from Baldwin. But still, you can tell also as you read this complaint, which we have had, we've discussed with our experts beforehand what needs to be in here, what's appropriate, what the standards are, so we could explain in the complaint properly what the standards are, not just what we think, what we believe, what research we've done, but what they're actually going to testify to. So in reading this complaint, I am pretty positive they already have experts hired and they've already discussed this case with experts, multiple experts, not just gun experts. All right, more facts of exactly what happened, which, we already know. Now, titles. I like titles. I like bold and underline. It tells us that they want us to focus on this. Defendant's aggressive cost cutting endangered the Rust cast and crew. Okay? This is really important. And we have a lot of claims like this, and it's true, that the specific negligence by Baldwin or by Gutierrez Reed or by Halls or by anybody specifically, that's one thing. But when the overarching theme and the umbrella corporation or the top company, and from the top down, when they create an environment that makes it impossible to do things the right way, that's where the negligence begins. And that negligence has a trickle-down effect. If you're too cheap to hire a lifeguard at a pool, yes, it's the company's fault. It's the manager's fault who didn't hire a lifeguard, but it's the actual parent company who won't allow them the money and the budget to hire a lifeguard. Just like here. They did not allow them the money to have the proper safety precautions. Like we had a case where they hired teenagers that wore lifeguard shirts for minimum wage instead of paying $15 an hour for a lifeguard. That was not okay. That was putting profits over people. So here, they talk about the cost cutting, which created a negligent environment and therefore was a but-for cause of the death of Helena Hutchins. Rust production companies were low-budget film production companies in the business of making films and were responsible for soliciting talent for the Rust production and hiring the crew to produce the film. The Rust production companies utilized aggressive cost-cutting practices during the Rust production that jeopardized and endangered the safety of the cast and crew of Rust. They hired Miss Hutchins. They began shooting aggressive cost cutting on 2 separate occasions. Miss Hutchins' guns at the Rust had been discharged. And now we have some cutouts of text messages that, again, we've already seen. We've now had 3 accidental discharges. This is super unsafe, and RAP should be fined like 30 to 45. Accidental discharges on the firearms, awesome. Sounds good. I don't think that response was saying awesome to the discharges. I think that was probably in response to the RAP, and 30 to 45 should be good. Mr. Looper, who we know is the camera guy. And he's got a lot of complaints about their living quarters, how much they're being paid, blah, blah, blah. But the important one we're going to hear over and over again is there were massive safety issues. 2 accidental discharges, 1 accidental SFX explosive that has gone off around the crew between takes. I personally suffer from pretty bad tinnitus, which is the ear problems that you have with loud noises. And the SFX explosive sent my ears ringing until I got home. Maybe he's going to have a claim. To be clear, there are no safety meetings these days. There have been no explanations as to what to expect for these shots. When everyone from production is asked, we are usually met with the same answers about not having enough time to complete the day if we rehearse, or that is, this is a 21-day shoot. Not great. Now we have more facts about the day of the killing. And again, they use the word killing here on purpose. And this is interesting, the way they set up the counts, okay? Count 1, negligent, intentional, willful, or reckless misconduct resulting in wrongful death against all defendants. There are different ways to write complaints. Usually we'll do a count per defendant just to make it clear. And if we want to file a proposal for settlement, meaning we are making an offer to just one defendant to just settle 1 count, we can say this is just as to count 1 because proposal for settlement, this is again in the weeds, you probably don't care, but proposal for settlements, especially in Florida, are held to a strict standard and they have to be strictly construed and strictly complied with the rules. So we'll say this $100,000 offer is just to Alec Baldwin and just for count 1. They decided to group all the defendants in 1 count, which again is fine. It's not procedurally wrong, just not really the way that we do it. The producers and the Rust production companies, each of them individually and collectively, once they made the decision to use real guns on the set, had a duty to. Now, if I'm representing one of the defendants, I am telling them that they need to be more specific as to what they're saying I did. I don't think this is a definite enough statement. I potentially could say I didn't even have anything to do with half of this stuff, but they're suing my company for these bad acts. We were in charge of ammunition. We weren't in charge of gun safety, or we were in charge of gun safety. We weren't in charge of ammunition. So I think sometimes you do have to be a little bit more specific to the defendant. But let's talk about what they had a duty to do. Negligence, duty, breach, causation, damages. So you start with duty. Provide a reasonably safe production set environment. Well, they breached that duty. Hire, train, supervise, and oversee crew who were qualified to ensure the safe procurement, storage, maintenance, transportation, transfers from person to person, and operation of deadly weapons, including the revolver that killed Miss Hutchins, as well as ammunition on the production set. And again, they know what Alec Baldwin has already said. They know what is in Gutierrez Reed's complaint. They know what's in the other complaints. They have so much information at this point from the parties involved. All right. C, design, establish, adopt, implement, monitor, and oversee reasonable safety protocols to protect the safety of all cast and crew on site, including Miss Hutchins. This could be right out of one of our complaints. So many places just have no safety protocols at all. And we depose a corporate representative and they say, I don't know what you mean by safety protocols. We don't have safety protocols. You would be astonished at the places you shop, the places that you enjoy, theme parks that just don't have any safety protocols in place. And it's really sad. And the only way that we can hold them accountable is when something goes wrong and somebody gets hurt. And then they implement more. Just like how we got the the seatbelt implemented, which, people hate lawyers. I get it, but some good comes from us too. Design, establish, adopt, implement, monitor, and oversee reasonable safety protocols, again, for the procurement of the gun. Train all those handling firearms and basic gun safety rules and the operation of the revolver fired in this case, including how to check and see if it was empty or loaded only with blanks. And that's important, okay? Because one of the excuses is going to be, oh, we didn't know. How could we know? It all looks the same. Well, they're saying, you know what? Somebody somewhere, one of these companies failed to train you properly because you should have been trained on how to know if these were blanks or live ammunition. So it just encompasses everything, which is true. You shouldn't be handling this gun if you don't know how to look and see if it's loaded or not with live ammunition, Come on. Ensure the guns were not loaded, but completely empty during lineups for shots. Ensure there was no live ammunition on set or placed in any of the guns used during the production. Conduct multiple inspections of every gun handed to an operator or actor to ensure gun was empty. If needed for a shot, only contain blank rounds and no ammunition. Inspect. And this all seems normal. I mean, there are certain things that are strict liability because they're dangerous instrumentalities like TNT, dynamite, fireworks, and guns. We know that these are dangerous, and that's why you need all this safety. Ensure the armorer was in exclusive possession of all weapons and ammunition at all times. That sounds familiar from Gutierrez-Reed's complaint. Prevent live ammunition from infiltrating the production set. We've heard that a couple times. Reasonably respond to complaints, concerns, and reports of cast and crew on the Rust production regarding weapon safety and take all action necessary to resolve such complaints, concerns, and reports, including shutting down or suspending the production, delaying the production, inspecting all weapons and ammunition on set, and auditing records to ensure all personnel were adequately trained in weapons handling and safety. And investigate all unexpected near misses or discharges of guns or explosives on set to determine the root cause and prevent any other weapons safety breaches, which I'm guessing they did none of. Now, defendant Baldwin pulled out on his lonesome, mentioned by name again. He had a duty to learn the gun safety rules before picking up a firearm on set. He would tell you he knows them. Learn how to safely operate and self-check the specific revolver in the case to make sure it was not loaded or was loaded with blank rounds. He would say he does know how to do that, but that's not common practice, and that's not his mode of operation in these cases. He's the actor when they call cold gun. That's their job, so he responds or relies on them. Always treat the gun as if it were loaded. Well, he definitely didn't do that. Never point the gun at any person. Didn't do that. Be aware of the people present in the direction in which he's pointing the gun and beyond. Keep his finger away from the trigger or not operate the revolver hammer until he decided to shoot. So they've combined this. And why do you think they did? He obviously said he didn't pull the trigger. He's going to say he kept his finger away from the trigger. But they're saying, listen, in the press conference, we heard the lawyer say you have to pull the trigger in order for the gun to go off. And that's what their experts are going to say. But just in case the jury believes that you can discharge the weapon without pulling the trigger and just by pulling the hammer, he's going to say you still shouldn't have pulled the hammer until you decided to shoot. That still was negligent. Even your argument and what you did was negligent. Ensure the persons hired as armorers were experts in the firearm safety. I guess because he's a producer, I don't think every actor can necessarily control that, and they don't make the decisions on who gets hired as the armorer, but okay. Conduct or observe a visual inspection of any weapon before taking possession of the weapon. Never aim a deadly weapon at cast and crew. Ensure any cast crew are protected against any potential discharges. Avoid recklessly discharging any deadly weapon, obviously. Each of the defendants, Gutierrez-Reed, Seth Kennedy, had a duty to exercise reasonable care in the procurement, inventory, storage, inspection, etc. All right, people are asking how to find the merch. To me, it just says, let me see if I can copy this, but I can't tell if this is like if I'm logged into something. Let's take a second. That's what's coming up in my search bar. If it doesn't work, I apologize, and we will post it in the comments, and we'll post it. It'll be posted on all our social media, and it'll be posted on our actual YouTube page. Oh, thank you, Kay, for the super sticker. I didn't see that come through. Thank you. Get you a shirt with that. Okay. Defendant Halls had a duty to provide a reasonably safe production set environment, refrain from delivering deadly weapons on the production to actors' usage without the necessary background training or experience to do so. And again, we're getting a lot of this from everywhere where, okay, good, the link works. We're getting a lot of this from everywhere where we have seen this in Gutierrez's complaint and other complaints. Alec Baldwin's interview, again, this is coming straight from that. We know Halls was transferring the gun and he shouldn't have been. Inspect any weapon. Accurately report the scope, nature, extent of the visual inspection. Investigate and reasonably respond to complaints. Because again, he's an assistant producer, I think, or assistant director. So he's a higher up. So he is one of the people that needs to investigate this stuff. The producers and the Rust production companies negligently did the following acts. Chose to hire the cheapest crew available rather than hiring, training, and supervising crew who are qualified to ensure the safe procurement, storage, maintenance, transportation, and the reason all this is important is, all of this language: procurement, storage, maintenance, transportation, transfers from person to person, and operation of deadly weapons and ammunition. The reason all that's important is because each person or defendant may have done one of those things. So you can't just say the procurement of a weapon. You can't just say the storage of a weapon. You can't just say the storage of ammunition. You've got to do all of this: the maintenance, transportation, transfer, storage, procurement, each time you discuss what they negligently did. Knowingly hired a wholly unqualified armorer. Chose to require the armorer to split time working as a second role as the assistant props master, which again, we've heard over and over again, from Gutierrez Reed, that her time was split and she was paid peanuts. Rye Davis, what's up? Glad you're here. I couldn't possibly start over. I wasn't even going to do this in the first place. Chose to cut corners and not strictly enforce the industry standard gun safety protocols. Again, I'm not reading every word. You guys can see most of the words on here. Chose not to require that all actors be trained in basic gun safety. And again, this stuff takes time and money. So this is why they didn't do a lot of this. Chose not to require all cast and crew protected against the risk of firearms at all times. Chose not to require multiple inspections of every weapon handed to the operator, including Baldwin. Chose not to ensure the armorer was in exclusive possession of all weapons and ammunition at all times, except the extent necessary for shooting scenes. Chose not to ensure all operators of a real revolver, including Baldwin, had adequate training, background, experience. Chose not to investigate the complaints. In addition to these acts, now to me, this complaint is a little bit clunky in that I would like it broken down, probably potentially each one count per defendant. That's just me kind of being OCD, but each count, each defendant, what you're saying they did, what negligence they have, make it a little bit more specific. Because if he settles with one of these defendants, it's going to make it a little bit more difficult, I think. But what do I know? Defendant Baldwin recklessly or willfully, that's a higher standard, committed the following acts or omissions: chose to accept the weapon that was not inspected, chose to handle a real revolver during a lineup scene instead of a stand-in prop, chose not to conduct or observe visual inspection of the gun, took intentional acts to allow the firing pin, like our expert said, of the revolver to hit a bullet and cause the revolver to be discharged. This is interesting, including pulling or cocking the hammer and releasing the fire pin. So this is really interesting because in his press conference, he said you can't shoot the gun without pulling the trigger. So I assume that's what his expert said. The gun experts at Mad Dog that we talked to said this could happen because the firing pin and pulling back the hammer, which is kind of what he's saying as a backup argument. Maybe you shouldn't have even pulled the hammer because it sounds like if that hits the firing pin, hits the bullet, then boom, the gun goes off. Pointed the gun at Helena Hutchins and the cast and crew of Rust within a dangerous distance and without any personal protection for them, and recklessly caused a deadly weapon to discharge, which is a criminal offense in the state of New Mexico. Alec Baldwin is not going to be happy with the verbiage in this complaint. Gutierrez Reed and Seth Kenny recklessly or willfully procured live ammunition and allowed it to be used. Failed to inspect each and every dummy bullet. Yeah, shaking the box, probably not good enough, as we've discussed. Didn't inspect each one. Chose not to inspect the weapon. Did not accurately report or disclose the scope, nature, and extent of the visual inspection. So my guess is their experts telling them that that is part of the procedure you have to do in gun safety, is not just do the inspection, but report and disclose the extent and nature of the visual inspection. Misled the cast and crew regarding the inspection, purposely saying cold gun even when it wasn't. Chose not to adequately train and supervise the cast and crew on the Rust production set. It's 9:30. I do want to get back in the chat here in a minute, but I'll try to finish this. Halls negligently, intentionally, recklessly, or willfully, and negligently did the following. They're adding this language in because they want punitive damages, which we'll get to. Declared the revolver safe without disclosing his failure to fully check the weapon. That's a big one. Did not inspect the weapon being transferred. They're assuming he didn't inspect it to make sure it was just dummy bullets, since in fact there were live ammunition in there. Did not accurately report. Did not reasonably investigate complaints. And again, that intentional or willful language is important, as you guys probably know by now, for punitive damages, for damages that punish, for the big numbers. All right, each of the defendants' actual omission were the proximate cause. All right, we'll come back to loss of consortium in a minute. Prayer for relief. Let's see if they ask for punitive damages. Compensatory damages, fear, pain, suffering for Helena Hutchins after being shot. Oh, this is an interesting little nugget. So when someone's killed, in the chat, do you think they can collect, or their estate can collect, for pain and suffering? Yes or no? Let me know in the chat. Loss of value of life and enjoyment of her life, household services, earning capacity. She was probably going to make a lot of money. They can collect that. Funeral and burial expenses, aggravating circumstances surrounding the wrongful death, the loss of love, companionship, comfort, care, and assistance, protection, affection, society, guidance, training, assistance, and moral support of Miss Hutchins. That's basically loss of consortium. That's what that is right there. Punitive damages, an amount to be determined at trial, pre-judgment and post-judgment interest, costs, such other relief as the court may find. Again, they didn't ask for attorney's fees. Doesn't seem like they're statutorily protected here or allowed here. But yes, they did ask for punitive damages. That's what I wanted to see. Okay, let's go to loss of consortium real quick. 42 years old, Matthew Hutchins, and the loving, close, dependent relationship. The nature of their close relationship give rise to loss of consortium claim by Matthew Hutchins, who, but for Helena Hutchins' untimely death, would have continued to rely on her for guidance, companionship, assistance, and support throughout their lives. She was also the mother of a 9-year-old son, loving relationship, and the loss of consortium of his mother, directly and proximately caused by the defendants, suffered loss of consortium. But I really like this explanation. The loss of love, companionship, comfort, care, assistance, protection, affection, society, guidance, training, assistance, and moral support, because that is true. And when you lose a mother or a wife, you deserve more money than the world has for losing this. I believe that everything I've got. So that is our brief deep dive, if such a thing exists, of the complaint filed against Alec Baldwin and lots of other people by Helena Hutchins and her family. We will probably snip that out and make it its own video so that we can just kind of post that for people that just care about that, since there was a lot of requests for that. So we'll probably cut that out and make it its own video as well, but you all got to hear it live. Remove, stop screen sharing. All right, let's quickly go through the chat here, see what we've got. Jack Hideous, yes, I am in fact a lawyer. At least I play one during the day. I don't really know where we started. Let's start here from the super sticker. Alec Baldwin is not locked up. Don made it. What's up, Don? We've been talking about you. Yep. Yeah, Don, email us, lawyeryouknow@gmail.com. Shirt size and address if you want us to send you a shirt. We were going to send you the one with your design on it, but you can pick whatever design you want, and we'll send you that shirt. Michelle Mosby, cost cutting is always bad for safety, but I heard in the very beginning that some of the cast had been using the gun for target practice, playing during breaks. Correct. Jack Hideous, sounds like they were trying to run the film the corporate way, safety all the way, unless we have to pay. That's a great slogan. I could use that during closing arguments. Safety all the way unless they have to pay. I will use that, Jack Hideous, and I'm not going to shout you out because I don't know if that's your real name, but Jack Hideous might scare some jurors. Nerd love, good. Get it, get it. Keep pumping on the treadmill. Keep it going. Hi from Japan. Awesome. Case by case at a time I can watch. Yeah, it looks like a pretty successful. We got like 130 people on here right now. So that's cool. We got the link in. All right, good. People saying it worked. All right. Tina, recently got to watch Ghost, Point Break, and Roadhouse at work. I love Roadhouse. My wife likes Ghost. It's all right. Whoopi was pretty good in it. But Point Break and Roadhouse are classics. Don, yes, I did shout out that not so subtle hint. I mean, I think it's absolutely a solid case. Absolutely a solid case. Now, will they be successful? I don't know. But I think that at this point, it looks like a good case. All right. Jack Hideous, I'm not going to put your comment on the screen, but that actually is a real part of it. And it's not really a joking matter, in my opinion. If you're married, that is important. Intimacy is an important part of marriage. It can be awkward to discuss in a case like this, but we absolutely discuss it and we talk about it. We talk about it a lot. And that's something that goes away that shouldn't have gone away, and nothing you did and nothing she did and somebody else took her away from you. And it's absolutely a part of it, part of loss of consortium. All right. Yeah. Thad the man had similar thoughts. It is important. Jack, you better get on the copyright quick. I talked about it a little bit on one of the lives. I didn't do a full video on it. I'm not going to do a full video of every single part of the trial. That would take forever. I just can't do that. In case anybody that's on the live doesn't know, I still am fully practicing and will always be a fully practicing lawyer. Full caseload, love it. Will never stop doing it. I'll do as much YouTube as I can, as much as time allows. I did the prosecution's opening. I did the defense's cross, which I posted today, which I think was great. But we can talk about the defense opening right now for a minute. I thought it had some good points. I thought personally in an opening, he responded a little too much to the prosecutor. In closing, you do a lot of that. I think he responded a little too much to the prosecutor. It was harder for him to get kind of a succinct story all the way through. He was testifying while the video was showing, got objected to and kind of shut down, but he was able to get some argument and testimony going. But you know, maybe he didn't know what some of the stuff was going to come out. I would have pointed out a lot of stuff that came out during the cross that I broke down. I thought it was a fine opening. I didn't think it was a home run. I don't think he got ahead of the prosecutor or anything like that. He did point out the entire row ahead, an entire seat to the right. He did point out how that was kind of outlandish, which I thought was good. So I thought he got some points for it, but I didn't think it was a home run or anything, completely special. Let's see here. All right. I've gotten to the bottom of the chat. I've hit most of the questions. I really hope you guys all enjoyed it. Check out the merch. Go get it. And make sure you let me know how it is when it shows up. I'm going to order some too, like I said. This was a fun live. It was kind of fun doing it a little later at night. Felt a little bit more chill. Nobody here at my office. No calls or anything interrupting me. Kids are already in bed. So this kind of worked out. Next week, we're going to do another live 1 weeknight. I don't know which one yet, probably around the same time. But thank you everybody for joining in. This was a lot of fun. Hit the like button on the way out if you haven't already. And if you don't subscribe, I don't know why you're here, you're chatting it up. Make sure you go and subscribe as well so you can, and hit the notification bell. We saw some people say, oh, they didn't know video popped up, or a couple people that showed up late, which I'm sure Dawn and some others have hit the notification bell already. Make sure you hit that so you don't miss future lives. It's a lot of fun. I get to a lot of comments and questions. That's my personal favorite part about the lives. I can do a video and break stuff down at any time, but the lives are fun, and we've kind of dedicated to try to do it every single week this year in 2022. And we've hit our mark so far, all the way through February, basically, at this point. So appreciate you all. Until next time, I'm out.